Um, Barbara, are you on as well?
I am.
Okay, great.
Hi,
Why don't you introduce yourself and then we'll get started.
sure. My name is Barbara Wong, and I work very closely with startups and companies in the California area. We help people basically everywhere, but most of our foreign nationals and clients are in Northern California. And we do have quite a few H-1B cap petitions and questions that arise with regard to this. So hopefully this seminar is going to give you a good overview of some of the things to keep in mind as you navigate through this process. Or if you have any questions, please don't hesitate, like David mentioned, to go ahead and ask.
Yes, excellent. So we're going to go over some basic information first prior to getting into more specific information. So for those of you who are pretty familiar with the H-1B process, this may be quite a kind of a review, but I did want to go over that specifically. First of all, what is an H-1B? Obviously, most people who are applying would know that it's a specialty occupation visa. Um, Specialty occupation, and there's several issues with respect to the H-1B. Obviously, what is a occupation? How long someone can stay in the United States? We're going to talk about how much someone needs to pay an H-1B worker if you're an employer. We're going to talk about the cap gap, which is basically for people that are currently in optional practical training and who apply for an H-1B when their optional practical training expires, how they can stay in the United States during the adjudication of their H-1B. And then we're going to talk about costs. The first part of this, before we start with the whole discussion, is to inform everyone that there is a quota for the H-1B visa. Um, this is the biggest issue in terms of determining, especially from the employer's perspective, whether an employer is going to sponsor an H-1B person, because the odds of that person being chosen for the H-1B lottery, which is basically what happens these days because the number of applicants is much greater than the number of slots available. It's important to know that there are at this point, and again, every year can be different, there's probably only about a 35% chance, and maybe a bit more if you're a U.S. master's degree holder, to obtain an H-1B. That doesn't mean you shouldn't try, of course, but it is something that we need to be aware of. This year, there are a total of 85,000 slots, and that's true every year. Um, but there were approximately 233,000 applicants who applied in April of 2015, which was the earliest time you could apply last year. Although no one knows, we expect to see about the same or even greater numbers this year. So if you're a graduate with a bachelor's degree, you may only have about a 30% chance of making the lottery. Out of those 85,000, there's 20,000 of them that are allocated to master's degree recipients. It has to be a U.S. master's degree. So if the applicant has a U.S. master's degree, it is possible that you would get into that 20,000. So basically, what happens is once one applies in the master's degree slot, they're first put into a lottery for the master's degree, and thereafter they're put into a lottery for the regular bachelor's degree. So they get like kind of two chances at it. So their chances of being chosen for the lottery are increased, well, substantially, I guess. So I haven't done the math, but I would think it's probably more like 40%, maybe a little bit more, that you would be chosen for the H-1B lottery if you are a master's degree recipient. Barbara, would you maybe want to explain to people briefly what how a specialty occupation is defined by the regulations?
Absolutely. Just a quick question about the master's degree.
Yes.
With regard to schools that are maybe like for-profit, would
Ah,
that affect their ability to
yes.
qualify?
That's a very good question, and that actually that issue just came up today in our New York office. There was someone, I believe, like in a California school who had looked at who had a master's degree, and our office. On a regular basis, if we believe that the school may be a for profit, we actually check that. So it's very important because if it's a nonprofit, I'm sorry, if it's a for profit master's or institution, um, the regulations provide that that person cannot use the U.S. master's degree quota or the U.S. cap. They have to go through the bachelor's degree quota. So they can't basically take advantage of those 20,000 extra slots.
Okay, very helpful.
Yes.
Now going to the specialty occupation, as David already mentioned, the H-1B cap does have some limitations in terms of who can qualify. A specialty occupation generally requires the theoretical and practical application of a body of specialized knowledge, along with at least a bachelor's degree or its equivalent. So one of the things to keep in mind is that if you're offered a position in the U.S., the position should be related to your field of study, and the position itself should require, at minimum, a bachelor's level education. Some of the examples on this slide kind of give you an idea of what areas are typically seen as positions that would require, at minimum, a bachelor's level education. And we also have a list here that goes through some of the job titles you often see for H-1B occupations and the types of companies that would sponsor them, and then the background in terms of how the individual beneficiary would qualify.
Barbara, what's the number one specialty in your opinion?
I think the number one users of H-1Bs are a lot of technology firms, such as computer systems engineers, computer science type folks. A lot of the big companies like the Microsofts, the technology companies, at least in the California area, that's the normal large user of H-1B numbers every year.
It's interesting to look at statistics. I
Mm-hmm.
believe the USCIS comes out with statistics in terms of the types of positions that are applied for. And I think it's something like 80% of the positions are computer related. So
Wow.
it's really, although, and interestingly though, we do have a large number of non-computer related types of positions, especially on the New York side of our practice. But and I would say the other one that's big is accounting. We have a number of those as well. So that being said, um, if you're not an accountant and you're not a computer person, a tech person, software engineer, computer specialist, that kind of thing, you still can apply for an H-1B. But because the USCIS sees less of these, generally there's a higher level of scrutiny on
Right.
that are given to the non-tech types of positions. So there's sometimes more difficult cases. I guess that's what I want to say. But
Yeah,
that's
I totally agree. And
yeah.
yeah, okay.
Yes, exactly. So uh, basically, you should certainly try, but when you have a non-tech position, it's a good idea really to check with an attorney and make sure that those positions work in terms of the H-1B visa. Um, some more basic information. The H-1B visa has a duration of a total of 6 years. The initial duration of stay is 3 years. After the 3 years, if one is employed in the same position, they can do an extension of stay for an additional 3 years for a maximum of 6 years. Um, in the event that an H-1B holder applies for permanent residence, known as a green card, at least 1 year prior to the expiration of those 6 years, that person can extend their H-1B in 1 year increments, and in some cases in 3 year increments, depending on the progress of the green card application, until such time as the green card is either denied or fully adjudicated. So, and that was something that was became a law in about 15 years ago, and has been an important part of the law to allow people that have to wait a long time basically to stay in the United States, because way back then it was taking a long time for green cards to be processed. And even today, if you're from India or China, it could take more than 6 years to obtain permanent residence, depending on which category you apply in. So uh, actually, that's an important benefit to H-1B holders that doesn't exist for holders of other work visa statuses.
So David, what if I was getting my bachelor's degree and then I held H-1B status, but then I decided to go back for my master's degree and I quit my job and I switched back to F1 status? What happens to those maybe 2 years that I was working after my bachelor's degree?
So uh, there's a rule actually that allows people to recapture um, unused H-1B time. So in your example, Barbara, the person would have been what we call counted against the cap, assuming that the person worked for a profit organization and was counted against the cap. So if that person, for instance, did get their master's degree and then found another position, they would be able to obtain an H-1B irregardless of the cap. So they wouldn't have to wait or worry about the lottery. So that's something
Yeah,
that's important to note, because those people may be able to find jobs more easily, because employers may will know that there's not the same risk, because they're not subject to the cap.
got it.
Barbara, do you want to talk about what the prevailing wage is?
Sure. One of the requirements for the H-1B petition is the U.S. government wants to make sure that the U.S. employer isn't hiring an H-1B worker to avoid paying U.S. workers what the U.S. government would consider a prevailing wage. And this is one of the reasons why there is a requirement here that the H-1B sponsor must pay the prevailing wage for the occupational classification in that area of employment. So the U.S. Department of Labor looks at two factors. They look at where the job is located, including the city and the state, and then they look at the position itself, what the duties are for this job, is it full-time or part-time, and how many years of experience and education that the employer is asking for. So with regard to the prevailing wage, the government wants to see that the wage is actually an average wage that's paid to individuals that are similarly employed in that specific area of intended employment. And the U.S. worker actually has to be paid, can be actually paid less, whereas the H-1B worker has to be paid the actual or prevailing wage, whichever is higher. So one of the things to keep in mind is that the government is actually going to make sure that if an employer wishes to hire an H-1B worker, that the employer actually needs to meet what they call the prevailing wage or the actual wage. And the Department of Labor actually provides this online, so everyone can go online and see what the wage is. But you can actually look it up under the OES category on the Foreign Labor Certification Online Wage Library. And we provided a link here on this presentation.
Right. So that's important, because if you sort of would like to know about what wage would be appropriate for your position, you can actually do a search, and you need to plug in the state, the county, and the position. And then you'll see a number of levels of wages, level 1 to level 4. And, again, it depends on the number of years required for the position, but generally, if it's an entry level position, you may be using level 1, and if it's a position that requires, say, 2 years of experience, you may be using level 2. That those particularities would be determined by the employer in conjunction with the attorney. But basically you can get a good idea at least of what kind of wage would be required for your position. And so I would definitely recommend, if you're looking to, from the employer's perspective or even from the applicant's perspective, to take a look at that website, because it can be very helpful in guiding you going forward. Um,
Now,
yep.
one thing just to mention here, and David's absolutely right about that, but some employers do actually use their own wage survey. So, for example, if you feel that that wage isn't what you're being offered, it doesn't mean that it's necessarily the wrong wage or it's not the prevailing wage. The government does allow employers to actually use their own surveys as well, as long as they meet the requirements. So that's one possibility for a prevailing wage sometimes if there's a discrepancy.
Absolutely. Um, Okay, so going back to the annual limits, which we spoke about, so I'm not going to spend much time on this, except to mention that there are certain exemptions for people on the H-1B. One of them is a current H-1B who has was extending his or her visa, as well as a person that's doing a modification. And we'll talk more about what a modification means, but essentially, if the employer has changed locations, if there's a change in the job duties, a change in the title sometimes, those kind of things would require an amended petition. Um, if you are changing jobs, you need to file a new change of employer H-1B. But again, if you have an H-1B already, you would not be subject to the cap. There are also statutorily exempt employers. That means basically institutions of higher education or a nonprofit research organization that is generally affiliated either with the government or an institution of higher education. One thing to note is that just because a company is a nonprofit does not mean that they would qualify. There are additional requirements. Um, of Recently, there was a memo. I think it's still in the proposal stage, but I don't recall if it's actually become part of the USCIS rules, that kind of uh, clarifies the meaning of the exemption with respect to those nonprofits that are affiliated with the institutions of higher education. And it looks like they're going to make it a bit easier for those affiliations to be used in helping companies become cap exempt. It's not clear yet exactly what's going to happen, but it seems to me that from reading the rules, it may become a little easier for employers to meet those criteria and become cap exempt. Um, okay, so denials. Uh, we don't have recent statistics on this, but this next slide gives you an idea of the rate of denials, and this is a denial after one is already chosen for the cap. So uh, if you've been chosen for the cap, um, you still have to be approved. And in fiscal year 2007, they increased from 11% to 29% in fiscal year 2009. And requests for evidence rates rose from 4% to 18%. So there's really, a difficult sometimes hurdle to overcome. And the figures include renewals and new H-1Bs. But again, there can be what's called an RFV, and those come quite often for cases that aren't kind of what I said before in terms of the traditional software engineer kinds of cases. The the non-traditional cases generally receive a higher level of scrutiny, and you would get what's called an RFE, which is a request for evidence. What that means basically is the government is going to send your attorney or your employer a list of about 5 pages of questions specifically asking them for more information about, sometimes about the company, sometimes about the position, to prove that it is in fact a specialty occupation. So those are things that are happening basically.
So David, quick question. What if I'm going to graduate on April 15th
Yes.
instead of April 1st of this year? Can I file my H-1B petition and then address it at the RFE stage? Because I won't have my degree and my transcript's not ready yet because I didn't really graduate yet.
I believe at the time of filing, you have to have a bachelor's degree. So I think that it would be difficult to prove once you file that you've obtained it after the filing. So I think that would not, you wouldn't want to apply for an H-1B under those circumstances.
That's helpful to know.
Yes. Now, Barbara, maybe you can discuss timing, what the deadline is. Why do people have to apply on April 1st? What would
Mhm.
that be? Why is that important?
It's important because the government's fiscal year runs from October to October of each year, and the regulations allow employers to file an H-1B petition 6 months prior to the beginning of the fiscal year. And that's why the April 1st deadline is one of the things we always keep an eye on, even though the validity of the actual H-1B won't be till October. So moving forward, a lot of folks are working on their H-1B caps now, even though the reality is, even if it was approved, the validity date of that H-1B cap approval won't begin until October 1st. So in terms of our processing times, normally employers would suggest we would suggest to all employers and even the applicants to start thinking ahead, and it's already the second week of February to start planning ahead to get all the paperwork ready. And we actually have all the cases ready for filing before that date, so that once the actual April 1st hits, the petitions actually arrive on that date.
Yep. So it's important to file on time. Barbara, I have a question from someone in the
Yeah.
audience. Maybe you can take this one since it's kind of in your area. The question is as follows. For startup companies, can they hire people with any salary that they can afford? This will encourage the young stage startups to hire international students. Can you speak on that one briefly?
Yeah, that's a really good question because we sometimes see individuals that are willing to work for startups for stock instead of salary, and the stock is speculative since it's not a guaranteed amount. And the U.S. CIS regulations and the immigration regulations actually require that a prevailing wage be met, because the goal from the U.S. perspective is to protect the U.S. workforce. And the foreign workers' limitations in getting this opportunity it requires the employer to make some concessions as to how much they'll pay in terms of the offered salary. It has to be the actual or the prevailing wage, whichever is higher. So the answer to the question is probably not. In terms of a student volunteering their time, I mean, that's a separate issue. In terms of H-1B, though, I don't think that's a possibility.
Yes, it doesn't make much sense, Barbara, obviously, from my practical standpoint, because the hope is that we want to encourage startups to be successful in the U.S., and we would love to see foreigners be able to assist that. And in fact, a lot of startups in the past and that have become multinational corporations were started by foreigners. So it's a great, it would be nice to have that, but unfortunately, the government's point of view is more the protection of. Well, I mean, I think unfortunately, maybe some people may not agree, but that the idea is to protect U.S. workers rather than foster encouragement to startups to hire foreign workers. So they're basically the idea behind
Absolutely.
the prevailing wage is they want to make sure that the worker is being paid at least what a U.S. worker would be paid, if not more, to give U.S. workers the same chance to be employed in those companies. So that's
Right.
behind it.
Uh, and that's a really good point, David. And one of the things I've seen some, opportunities for startups is to have someone be hired part-time, because the reality is then they may be able to pay a little less for the actual wage as opposed to a full-time employee where they're obligated to pay a higher wage for the annual salary. So if the hours are 20 hours a week as opposed to 40 plus hours a week as a full-time salaried employee, that may be a way to address this as a temporary solution. It's not a long-term solution, but there is a possibility of getting a part-time H-1B as well.
Yes, that's correct. Just be aware, though, that the government does has initiated site visits in the past, and part of the site visit is to check to see that the employer is paying the employee for the time that they're working there. And unfortunately, there are some employers that may file for a part-time position, but have someone work on a full-time basis and pay them half the wage so that they can think they can comply, but they actually aren't complying. So it's very important to if you are hiring, if an employer is hiring someone on a part-time basis, that it actually be part-time and not full-time, and say that it's part-time, because we've seen that in the past as
Exactly,
well.
exactly.
Then you'll get your visa revoked very quickly. Um, Back to one of the issues that we discussed initially, and I'm going to explain in more in details now, the cap gap. So for someone who is in OPT and F1 status, as long as that person applies for their H-1B uh, on April 1st, or that week, whenever they're taking H-1Bs, and they have OPT valid at the time of filing, that F1 student can continue to work in the United States until such time as their OPT expires, of course, or until their H-1B is approved, if it's selected, or if their H-1B is selected and it's denied, they can work until they receive a denial, or until such time the USCIS informs that employee that or that the company that their H-1B is not selected. So it allows people to continue to work during the time of their uh, the dependency of the application. And that's an important thing for people so it doesn't interrupt their employment. Now, one caveat to this: if the OPT person under OPT's status expires prior to April 1st, but they're still in what's called the grace period. In other words, say their OPT expires on February 15th, but they have a 60-day grace period during that time. Well, if they apply during that grace period, so obviously April 1st would fall within the grace period under my example, they would be able to stay in the United States but not work, and then the other rules that I explained earlier would still apply. So that's what the cap gap is, and that's implemented every year for people in that situation. In order to use the cap gap, you need to, if you're a student, you need to inform your school of what you're doing. So, a notation can be made in the CVIS system. That's the system that the school uses to manage their I-20s. It's a government system. So that's just something important that you need to um, remember. And procedurally, the next slide basically explains exactly what needs to be done with respect to the DSO, and they need to get a receipt notice, approval notice, evidence of the filed application, and then the DSO will issue a cap gap I-20, so an extension of OPT until 9/30. The next,
So,
yes, go ahead.
David, just a quick question. What if I am a student and I have cap gap and I travel outside of the U.S. to visit my family in August.
Yes, uh, that usually poses a problem because um, we don't recommend it because the person is in the middle of applying for an H-1B, and uh, trying to obtain H-1B status through a change of status. And if they leave the country, that change of status could be deemed abandoned because they've left and sort of broken that status. So our recommendation is that you don't do that. You may also have issues with respect to your optional practical training card. Obviously, if your I-20 is updated, you may be able to travel, but because of the change of status issue, it may cause a problem. So we don't recommend it. Would you agree, Barbara, on that?
Absolutely. Yeah, it's very helpful to know.
Yep. Okay. So back to the cap. Just this is just an illustration of how it would work. Quickly, if your immigration status is F1, your H-1B petition is duly received for fiscal year 2017. Start date is 10/1/16. 2016, and your OPT expires on 5/31/2016, and the OPT grace period is 60 days. So these are the hypotheses for this little graph. Basically, you file on 4/1. During that time, your OPT is extended. Even though your OPT is expired on 5/31, you would be able, obviously, to work until then, assuming that your grace period ends on 7/30. The cap gap would basically be 7/30 until 10/1. And then in terms of work permission, from the end of the OPT until 10/1. And this would, of course, be assuming that your case is chosen for the lottery and ultimately approved. So this is just an illustration to give you a better idea of how the cap gap works. I just want to talk very briefly about some of the rules. In 2010, there was a memo that came out. It was an important memo. It is very important that if you are employed by a U.S. employer, that there be an actual employer-employee relationship, meaning like if the company is say a personnel consulting firm or placement firm, and you're merely placed with a third employer, and your personnel employer HR placement company applies for the H-1B and just pays your salary but doesn't have any control really over your employment, then that would not be allowed under the rules. So there's several different kinds of employment that are acceptable. Traditional employment obviously is what most people have. They go to an office, they work in the office, and on site, and they have a company, a boss, and whatever, and the control is obviously by the employer. Another type of employment that's okay is if there's offsite employment on a temporary basis, but um, as long as the employer has control, that's okay. If the uh, if the employer is placing someone long term at an offsite employer, as long as that employer has control over the uh, the employment site and control over the employer, then it is also an acceptable type of relationship. And those can kind of get tricky, but there are certain instances where that may be acceptable. What's not acceptable are self-employed beneficiaries. So you can't actually employ yourself and then obtain an H-1B based on that scenario. Um, we do have companies from time to time who um, well, I should say beneficiaries or H-1B applicants who actually would uh, employ, who would create their own companies essentially, and then want to obtain H-1Bs. We used to do a lot of those. We haven't over since the Neufeld memo, because it's become a bit difficult. They're not, if you're self-employed and you're the only one who starts the company and you're the only person that runs the company, then essentially it's going to be very difficult for you to obtain an H-1B. If, for example, you have partners and you have independent directors of the company, there may be ways of obtaining an H-1B even if you're sort of like a main member of the company. Independent contractors, you have to be an employee of an H-1B company if you wish to obtain an H-1B visa. Independent contractors, meaning people on 1099s, are not allowed to be H-1B. So sometimes you have employers that want to put people on 1099s. That's not allowed under the H-1B scenario. Third-party placements, again, we spoke about that earlier. Those are also not allowed under the rules. So that's important to know. Barbara, did you want to add anything on this?
Yeah, in terms of employment agencies, how have you handled those types of situations where the employment agency is actually the employer?
Yes.
And
Right.
okay.
So if the employment agency is the employer, we've had cases like this in the past.
Yeah.
It really, it's the actual employer and the person is working on site for the employment agency, there's no problem. If they're being placed somewhere, it really depends on how much control that agency has on the employee's activities. Most of the time, they're not going to have control over the activities, they're just paying the salary, and in which case, that kind of situation would not work under the H-1B regulations.
Right.
Okay, but Barbara, why don't you explain to our attendees what the cost is for applying for an H-1B?
Sure thing. The H-1B petition costs are listed here on the slide. The base fee is the I-129 petition, and the documents are all signed by the employer, and that fee is $325. The education and training fee for the CAP petitions, if it's under 25 employees, it's $750. And if it's over 25, it's $1,500. And then there's a fraud prevention and detection fee of $500. And if you wish or the employer wishes to secure approval of the H-1B or a request for evidence, some notification from the government within 15 days of receipt, it's an additional $1,225, and it's called the premium processing fee. Note that for the H-1B CAP petition process, even if the employer does opt for the premium processing fee, most likely they won't receive confirmation on the receipt of the petition until all the petitions are received and the lottery numbers are run through the USCIS. So what the USCIS will do is gather together all the cases that are received within the first 5 days. If the H-1B CAP petition numbers are exhausted within the first day of the CAP opening up, which is April 1st. And then once they get all the petitions, they're going to review them, and then at that point they will select the ones by computer lottery, generated lottery, which ones are being selected. And then if it's filed with premium processing, we should start getting emails and receipt notices so that the government can process the case in about 15 days.
Barbara, one of the questions that often comes up in the premium processing fee context is whether the using premium processing will increase the likelihood of being chosen in the lottery. Why would one use premium processing when they're applying for an H-1B CAP case? Does it help them? Does it give them a better chance of being selected?
It doesn't necessarily, and this question does come up quite a bit, it doesn't necessarily give them a better chance of being selected. However, it does give them some degree of assurance that their case has been selected a little bit faster than if the case wasn't filed with premium processing. And if the case is straightforward and the government's going to approve it, most likely the premium processing applicants or beneficiaries will actually be notified of the approval probably by June or July if there's no RFE, maybe sooner. I would say sometimes even May, if the processing time moves forward with the selection of the cases and the case will be approved. the benefit of that is that, of course, if you're a foreign national and you're waiting to hear, you don't have to wait as long. Another benefit is sometimes with cases that are not filed with premium processing, we do see the timeline move forward when there's a request for evidence and the case is not yet approved and it's October 1st. So we have seen cases kind of linger because of government delays, and it takes about 3 months, sometimes even longer, for the USCIS to adjudicate an H-1B petition that isn't filed with premium processing. Another piece of good news is that if your case isn't filed originally with premium processing, the employer or you can actually upgrade the petition to premium processing if it's selected for adjudication, and then you can also decide to do that at a later time. So you don't necessarily need to do that at the outset.
Right, and that and that's that. I think again, if the employer wants to know quickly, or if the employee wants to know quickly, it's not a bad idea to use. There, it is $1,225, but your visa, although it may be approved, it's not going to be valid until October 1st, even if you do use premium processing. We have some people sometimes that ask this question, Barbara. If someone has two offers from two different employers, can someone file more than one petition with the USCIS for an H-1B?
Right, that's a really good question. And right now, the government does not prevent another U.S. employer from filing a petition for a beneficiary that may have more than one employer that wishes to file an H-1B petition for him or her. So the answer is likely it's possible. Practically speaking, we've seen some confusion here because sometimes the USCIS will question why there's two petitions filed for this individual, even though under the regulations that wasn't something that was prevented in terms of the employer. Because remember, the employer is sponsoring the foreign worker. And if the foreign worker has more than one job offer and they're deciding, it's likely or possible that the foreign national may actually have more than one H-1B petitioner. David, have you had any negative experiences with this?
I haven't, Barbara, personally, but I certainly think that it could become an issue, as you said, because of the confusion regarding the same beneficiary. The reason why is because one thing that you cannot do is you couldn't apply for the same beneficiary with the same company. You couldn't file more than one petition because obviously people would think about filing 10 petitions with the government, hoping that one would be chosen. That you cannot do, and every petition is recorded with the USCIS, so they know obviously if there's more than one petition. But because of the fact that they're people with the same name with two different companies, it could cause confusion. I see exactly what you mean, but again, I'm not sure. I haven't had that specific problem come up. So I just want to keep going here a bit. One of the question that comes up is who has to pay for the H-1B petition. First of all, the USCIS has their rule, and then the Department of Labor has their rule. In general, as a law firm, we strongly recommend that employers pay all of the fees associated with the H-1B application, including the attorney's fees. But the rule is, from this USCIS perspective, that the training thing that Barbara mentioned earlier must be paid by the employer. They haven't really said anything with respect to the other fees. The Department of Labor, and this comes up in the context of an H-1B audit. So if the employer if the DOL does an audit on the employer, the DOL can assess fines or back wages if the employer requires the employee to pay the wage. So it's really up to the employer to decide what's better for him or her, for the company, and it's up to the applicant as well. But the issue is really one for the employer rather than the applicant. In other words, if the employer has a DOL audit, the applicant isn't going necessarily to have their visa revoked or anything like that. It's more penalties that could be assessed against the employer at that point.
Mm-hmm.
So one of the questions actually that came up from one of the attendees is, I'm going to I'm going to cover here with respect to the Simeo decision. So last year there was a case called a matter of Simeo, and that case basically said that when employers move locations outside of what's called the Metropolitan Statistical Area, the MSA, outside of the MSA, which is like usually a radius of about 25 miles, 50 miles, something like that. It really depends on the MSA. They need to file what's called an amended petition. Before that, before the semiotics decision came out, they could file just an LCA, which is a labor condition application. It's a lot easier to file, and that's something that's filed with the Labor Department, and you post it, and that's that. But now, again, if the work site location changes permanently outside of the MSA, a new H-1B application is required. And again, if and by the way, if it's within the MSA, so say like they within Palo Alto, the company moves from 4 blocks away to another building or something of that sort, then just an LCA, a new LCA would be required. An amended petition would not be required. But that's something that's come up very recently, and that's been clarified by the matter of Simeo Solutions case. Um, so uh, once so moving on here because we're running out of time. After approval, the DOL regulations require obviously that the prevailing wage be paid to the applicant as promised on the LCA. They have to be offered the same benefits as those similarly situated non-H-1B employees in the organization, and the employer has to keep what's called a public access file, which is open basically to anyone, to the public who wants to review it. And in that access file, there are a number of items which we can go over at another time because it's kind of voluminous. But needless to say, it has information about the salary and about other workers in the same position that need to be publicly available for inspection. And then again, if any material changes arise, to make sure that all necessary paperwork is filed with the correct government agency. Maybe it's an LCA, maybe it's going to be an amendment, again, depending on the situation. So those are important things. One of the things that's not on the slide, which is really important, is once one does receive an approval for an H-1B, if they travel abroad, they need to visit a U.S. embassy somewhere where usually from their home country, but there are also people that go to Canada or to Mexico, and they need to obtain a visa stamp unless you're Canadian, because the Canadians don't need a visa stamp. But if not, then you need to obtain a visa stamp, and to do that, basically the employee would bring a copy of their petition, generally the approval notice, and make an appointment at U.S. Embassy where they would have a personal interview with the consular officer, and that consular officer is going to go through to ensure that the position is in fact what the petition says it is, that the employer exists, that the person actually studied what they said they studied, et cetera, et cetera. I'm actually speaking to you from Tokyo right now because I work most of the year in Tokyo, although we have our New York office, and Barbara, of course, runs our California office. She's my partner. So I see a lot of applications at U.S. embassies here in Japan. And one of the things that I do on a regular basis is I help prepare individuals for these kinds of interviews. So it's really an important thing to make sure that you're well prepared for the interview, because I can tell you over the last 22 years that I've been in practice, I've seen quite a few people who were not prepared, who had a very distasteful surprise when their case was denied. because they were ill prepared. So it's really important not to think that just because you have an approval notice that you don't have to worry about preparation. There is an interview and there's a process that you need to be mindful of. Barbara, would you like to add anything?
Yeah, that's a really good point that David made, because one of the things that you see in the previous bullet was about material change. And one of the things that the memo that he mentioned earlier talked about was whether or not a change in work site would be considered material. And in the past, there was some confusion as to whether or not the government required an employer to file what they call an amended H-1B petition if the company grows. So with a lot of startups, they start off in a small location, but as they start growing, they actually move into a larger space, so their address changes. This ties into the USCIS site visits as well, because if the government can't find where you're located as an H-1B worker, they can actually revoke the H-1B as one potential result. They issued the memo, Simeo decision really talks about that particular issue, and that the government now set a bright line rule whereby if the company actually posts the new LCA at the new work site, if it's within the same metropolitan statistical area, which is defined under the Department of Labor, the person can actually go to that new location without the need to refile. So one of the things to keep in mind is that as the rules evolve with the government as well as with your employers changing, you want to keep in mind that you maybe consult with an attorney, or at least be aware of this issue and bring it up to your employer, because you may just be working and not thinking about it, and all of a sudden there's a problem with your visa because you go there to apply for your visa and you find out your H-1B is revoked, and because all the mail was sent to the old address, no one knew about it. So just something to keep in mind for purposes of as an H-1B worker, if you're a beneficiary, and even when you're an employer, just that there is a population that's not just like your every U.S. citizen worker where they can just go anywhere, but if there's any changes in their employment, if there's changes in the work site, check in with the council or find out if there's anything you need to do to update the government.
So just moving along here, thank you, Barbara. Site visits, I spoke about those a minute ago. Very important to be prepared for them. This is more something that the employer needs to be aware of, but good to see on the slide here, just to give you information. There are consequences, obviously, fines. Infosys recently was fined $34 million for H-1B violations. It takes a lot of money, so make sure that basically that the employer is employing the applicant in what they say they are and paying the wage. So again, DOL audits can arise in many different ways. I'm not going to spend a lot of time on this because I think a lot of our attendees here are actually candidates for employment as opposed to employers, but needless to say, for if employers are listening, disgruntled employees or even random audits by the Department of Labor or investigations initiated by the Department of State at the embassies can trigger an audit. And again, those can be onerous and rather distasteful kinds of investigations. So very important to follow the rules. So I have some questions, Barbara, in the last couple of minutes, so I'm going to go through those. Maybe I'll give you this one and I'll read it to you. I have two questions. How long does it take to put together all the documents for the application? Is there any preference if I work for a nonprofit organization in terms of the lottery or application fees? You want to take that one, Barbara?
Sure. The first part of the question about how long it takes, it really depends on the employer, whether or not they previously filed an H-1B petition before. The reason why I say that is that if the employer had never previously filed or sponsored an H-1B worker, then the likelihood is that we would need some additional information to verify their federal employer tax ID number at the Department of Labor stage for the first labor condition application. And that's the document that confirms that they're offering the prevailing wage or actual wage, whichever is higher. That process can take an additional several days, and then the LCA can take 7 to 8 days for adjudication. That is the first step that needs to be taken before the actual documents for the H-1B CAP petition filing can be prepared. And then I think with regard to just timing, We actually do say that you start as soon as possible. So for any of the H-1B cap petitions we're looking at now, I would say now is the time to go ahead and prepare in advance. Even though it may end up not being filed until April 1st, it's best to have all the paperwork collected. So for example, I've seen employees have difficulty getting their degrees or their transcripts. Sometimes that can take several days. So if you start off collecting your own paperwork as you start searching for an H-1B employer, or maybe your H-1B petitioner starting off now, at least you've done your part, whereby you actually have all the paperwork together. I'm sorry, the second part of the question was, David?
Um, she works for a nonprofit organization.
Nonprofit?
Does that help her in any way?
Unless it's capped exempt, the answer is likely no. One potential benefit would be the salary. Well, I don't know if it's a benefit for the employee, but the salary may actually be in line with, a nonprofit, so they may have a little flexibility there. For example, some nonprofits may have a lower salary. Most of the time, there's no in terms of prevailing wage, so that if they have a hard time meeting a salary requirement, they may actually have the ability to use a lower wage. But in terms of the processing of the H-1B cap petitions, as David mentioned, unless they qualify to be capped exempt, the chances are just as likely as a regular for-profit company to be selected or not selected.
Right, exactly. Um,
Yeah.
I'm just thinking back, Barbara, if it's a nonprofit, are they exempt from paying the training fee in some instances? Or the fraud fee?
Dave,
I think, go ahead.
is it the training fee or the
You know what? I don't
education
have,
and
I'm
training?
sorry. I'd like to give you the correct answer, and I don't have it at the top of my head, but I do remember in the back of my mind that I think there may be a way of exemption from the training fee, depending on what type of nonprofit it is. But I'd have to get back to you on that. So that may be something. I just don't remember. Let me just go back to the next question. I have someone who's asking, their OPT is expiring in August. She wants to apply for an E2 as a Canadian. When should she apply for the H1 the A2 if she does not wish to get the H1B? And that's really something that's outside of our discussion. But basically, for an E2 as a Canadian, you probably would apply at the U.S. consulate or embassy in Canada, and so you need to look at the processing times for that. My guess is about two months or so prior to the expiration would be the very latest. But I would say, the earlier is better for any kind of visa. At least, if you can apply 3 or 4 months in advance before your OPT is expiring, that would probably be a good idea. If you apply for a change of status within the United States, you can apply for up to 6 months prior if you decide not to do the H-1B. Or what many people would do in this case, if the H-1B is a better case, apply for the H-1B, and if you don't get the H-1B, you probably have enough time at that point to think about an E2 at that point. There's another question quickly. How many days do you think the H-1B will be reached? The cap for 2016. It will be reached beyond a doubt, in my opinion, in the first week. In other words, usually the H-1B petitions are accepted for 1 week. So if you apply and it arrives on April 1st, or if it arrives on April 3rd, it will be within the selection. But beyond that is very, very unlikely that there will be H-1Bs available after that first week. I would say next to impossible.
Right.
There's someone who's asking. Yep, go ahead, Barbara.
Yeah, go ahead. Oh, one thing to remember is I know this is something that may not come up, but if it does come up if you're a student in F1 status and you are selected for an H-1B, make sure you go back to your international student advisor to update the CVIS form on your I-20, because a lot of times people just think, okay, I'm fine now. But, it's an important thing to remember for procedural and documentation purposes. And David, go ahead. You had another question?
Right. So there was someone who's asking what control means in the context of the employer-employee relationship. Basically, control means that an employer is aware and directs the daily work of the employee, that they can give directions to that employee, They can evaluate, they can fire and hire the employee. There's a bunch of criteria that are set out in a memo actually, and I don't recall every single one of them. But basically, it means like they're in a regular employment situation, and that's why placement is sometimes a very tricky thing, because a lot of times if someone is placed in a third organization, a third party organization, that third party actually has control over the employee, not the placement organization. So that's sort of what I mean. But there's specific memos on that stuff. So you can let me know if you have any. This person can contact me directly if they have any questions. We have another question that I sort of talked about, but maybe we need a little bit more clarification. Please elaborate on employees working in a geographical location other than the one mentioned in the LCA, working beyond a 60-mile radius of the county listed on your LCA. This is an issue for employers to hire international students. Is it true to tell them that the paperwork for this purpose takes only 10 minutes? I would say it probably takes a little more than 10 minutes. Again, if it depends on if it's like temporary placement or if it's permanent placement. And I believe I can't remember exactly the number of days, Barbara. Do you recall? Is it 90 days? For
Yeah.
There's temporary placement.
Peripatetic. Yeah, there's a peripatetic worker requirement. I believe it's like under 90 days,
Right.
whereby they can actually work at a different work site, but it's very limited, and most employers are not looking to send people out for that short of time. They're either having them work in a different location, whereby they really need a new LCA.
Right. So if it's more than 90 days, Barbara, wouldn't they have to apply that when under the Simeo decision, wouldn't they need to amend their H-1B?
Correct.
And
Yeah. So
and
that's,
if
yes.
if there's now what happens if you have employees working in several locations? Couldn't you put more than one location on the LCA?
Absolutely. And that's one way, if you can predict in advance that you're going to maybe need someone to work at two work sites. For example, it's quite common here in the area, in the Bay Area, that people may be traveling to the South Bay and then working in San Francisco. So that's something to keep in mind when you're actually preparing cases if there's two work sites. Remember, the salaries may be different depending on the area that the position is located in. And probably in New York, there could be positions that are located in New Jersey and New York State. So that may be something to keep in mind if there's two locations that the individual may be working at.
Okay, I have a couple of more, and then we're going to have to end.
Okay.
The lottery. How is the lottery determined? Basically, I don't know, but basically, my assumption is that the USCIS puts all of the applications into a system that randomly chooses the who's going to be chosen for the lottery. It's not like a first come first serve. Basically, everyone who applies within that first week is put together in the lottery, and then it's randomly chosen by a computer.
Yeah,
That's the way.
that's a really good point, David, because I hear people sometimes say, well, my friend who works at a big company got selected and I didn't. Did it matter that I was working in a smaller startup, or I took a job with a smaller company? And the answer is no, it shouldn't. The odds are that if a company is filing hundreds of cases, you may hear of more people getting it just because of the number of people that are working there. But I don't think it's an mathematical equation whereby if you work for a smaller company, you likely won't get selected for the H-1B cap. What are your thoughts on that, David?
Yes, I absolutely. I mean, it shouldn't matter. The government, if you believe what the government says, and I guess there's no reason not to, it's totally random. So it doesn't. They don't look at what company or who you are or what country you're from. It just looks. They just take all the applications and put them randomly into their system, and then generate 65,000 applications to count against the cap, and the rest are rejected. And that's the way I believe it works. So I just want to, we've run over a bit, so I'd like to, first of all, thank everyone who attended. Those who did not could not attend, we're going to put this up on our website and on YouTube, so they'll have a chance to listen to it offline. Thank you all for your questions. Our law firm, again, SW Law Group, we have been um, working with foreign nationals for over 20 years. We have our main offices are in California, in the Bay Area, in Silicon Valley, in New York, and in Tokyo, where I am speaking to you, from where I'm speaking to you, and Barbara is speaking to you from our Silicon Valley office. So thank you all for attending, and have a good evening or have a good day. Barbara, any last words?
Yep. That's it. And feel free to shoot us an email. Our contact information appears on this last slide. Thank you very much.
Thank you very much, all of you. Thank you. Bye now.